Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. Who are these guys? Dwayne Singleton, Irreverent D, is a criminal defense attorney in the state of Georgia. Benjamin O. Benson, aka Bob, is a personal injury attorney in Atlanta. On today's episode, the boys talk about client foibles.
I've had several where people tripped over the warning cones.
The warning cones?
Yeah.
Oh my God.
Irreverent D talks about his own foibles.
I'll say from personal experience, you only have to fall about 20 foot to break your neck.
It wasn't doing something like...
I was mopping a porch.
Yeah.
And Bob tries to pull one over.
Rudy Giuliani under subpoena? No?
You're trying to trick me. I know I'm being tricked.
Now, sit back and take a listen as Bob and Irreverent D talk law.
The gang's all here. Welcome to the Bob and Irreverent D talk law, and today we're joined by Jason Darneille, who is a insurance defense attorney. We wanted him particularly to come and join us to talk about some cases that are maybe controversial, and talk about like what we think about them.
So some of our viewers may be confused as to why you don't have him in a headlock and you're
Right.
just beating up on him or whatever, or he's just hitting you in the face.
I do have to say that there's, first of all, Jason and I are personal friends.
Right.
We went to the baseball game together last night.
Right.
But it's very much like, do you remember that old Looney Tunes cartoon where the dog and the wolf like show up together to work in the morning? And they say, Mornin Ralph, Mornin Sam, and they both clock in.
The big sheepdog, right? Yeah.
And then they chase each other around all day, and then they finish, and they clock back out and say, "Good night, Sam. Good night, Ralph." It's kind of like that.
Well, that's like everybody's like with me. They're like, I know you hate cops. And I'm like, I don't hate cops.
I hang out with them.
I don't hate DA's officers. You know, I have to work with them every day. I was like, I don't like people that, do crooked stuff. That's a big deal.
I don't like bad people.
Yeah.
Whether
But
they're
that's in
cops
general.
or they're exactly.
Preachers, deacons, whoever. Bad people I don't like.
And since we got to work together every day and we all need favors from each other, it makes more sense to get along.
Can I get a continuance to next Friday?
Right. That a lot of times, the clients that I work with understand because our clients are normal, reasonable people. But sometimes I've heard that other people don't understand. They say, "No, you should not like this person. You should. I need a bulldog," and to a certain extent, you do need an advocate who is persistent. Right. But bulldog maybe not quite the right.
Well, sometimes you get this correspondence going on between you and the judge about scheduling or whatever, and you really get into it, and the other side sends you a private text. It's like, what the hell, Dwayne?
What are you doing?
Why are you doing this?
I was supposed to be, I got thrown on a trial calendar for tomorrow, and my wife and kids are out of town, and I was looking at a 4-day vacation, and so I called the plaintiff's attorney, and I was like, hey, man, there's no legal reason to continue the case, but I have 4 days alone that I'd rather get to hang out, go to the Braves game. And he's like, yeah, I didn't really want to try it that Monday either. So we filed a joint motion to continue, and it's because we get along so well.
Right. I mean, that's an important thing. Well, let's go through the news. You guys ready to go through the news?
Let's do it.
And now, the news.
What I felt was super important in the news is that Donald Trump got his 4th indictment in Fulton County. Are we finally going to take this up?
No, I'm not talking about that.
We're still not going to take it
up.
up.
Podcast with you.
Certainly you don't with me.
I'm not doing it.
No, so we're not going to take that up, and we're not going to take up the only defendant jailed in Georgia election cases is out on bond. You don't want to take that up? Rudy Giuliani under subpoena? No?
You're trying to trick me. I know I'm being tricked.
Okay. This one actually is important, and it affects all of us, I think. In a previous episode, we covered the tort reform stuff that happened in Florida,
right,
at length, and what it might mean for us here in Georgia, right on time. There's this article, Governor Kemp to the Georgia Chamber of Commerce. These frivolous lawsuits, big awards, deter business. We got to do
Tort
something.
Reform. Yeah.
Tort reform. We
Yeah.
got to do something about it. And so I bet, as we watch the news in the ensuing months, that this, come the spring or end of when the legislative session gets going, that's going to be like the narrative, tort reform. That happened in 2005. Were you practicing in 2005 when that happened, or I had not started yet?
I was, but not in Georgia, because I
Georgia.
practiced in Alabama, and I was back in Alabama. Alabama went through a big tort reform.
They did.
They actually brought Karl Rove in back
Really?
in his young days, and he literally changed the law. And now the way the Alabama system's set up, they did an article in the Alabama version of the Daily Report. The Supreme Court's partisan. It's all Republican. They've reversed 75% of plaintiffs' verdicts over the last 10 years.
Good God, really?
Yes.
So insurance companies love that.
Oh, it's a complete business friendly law. You still have your rogue counties, but over there they also have pure contrib, which means if you're 0.1% at fault, you cannot recover. They have,
Good night, really?
yes,
What?
they have the guest passenger statute that if you and I are going to lunch, I can't sue, and you cause a wreck, I can't sue you for negligence unless I paid you. Like, you just can't sue from.
Oh, so if I'm riding in the car with a friend and they kill me, I'm just out.
Unless it's
Wow.
wantonness, but just for straight negligence, you're out.
No kidding.
Wow.
Well, I guess we don't have it that bad here.
No, that limits the the number of lawsuits tremendously.
So
Well-
that's on the belly of this thing, right? That's not good for you.
Correct.
I mean, we're doing away with both sides, with the plaintiffs and with the defendants, right? Wow.
No, I think it's gotten. I mean, some of the verdicts have been so out of hand
Right.
lately. Something's got to be done, but typically it swings back and forth. For a long time, it was very defense friendly. We're in a very plaintiff friendly, climate right now. That if you come in and do a bunch of tort reform, I don't know that that's necessarily going to fix anything.
What we've covered this in previous episodes. What we've noticed is that a lot of these kind of quote runaway jury kind of examples, nuclear verdicts, examples that are cited to by folks on your side are, as we look at the facts of them, we're like, yeah, but that's like really egregious. Like that's why there should be a big verdict in that case. Now, I'm not so sure in these other ones that we're talking about today. Let's talk about the first one. Here's the news item. An injured boy's family settles a lawsuit with a Georgia water park for $16 million. A Georgia boy's family. So this 4-year-old boy, here are the facts of the case. The 4-year-old boy was swimming at this Paradise Beach on Lake Lanier. I'm just going to pause there and just for everyone's edification, just say, as tragic as this is, we hear news stories about people dying at Lake Lanier
all the time.
nearly every weekend
Right.
during the thing. Like, it is known danger. I don't know that the water is particularly more dangerous at that lake.
I think there's just so many people out there. It's just
There's a lot of people out
just
there.
statistics. You got a bunch of people on the water, alcohol involved. We get deaths.
But there are a lot of just weird drownings there too.
Right.
That it's a 16-year-old goes under and just doesn't resurface.
Right, it does have kind of a haunted thing to it, right? Feel to it. Well, in this case, this 4-year-old boy nearly drowned. He was under the water for 10 to 15 minutes. His brain was starved of oxygen, so he had a traumatic brain injury. He had hypoxic brain injury, which means that's when your brain goes without oxygen for too long. It basically makes your brain into like a vegetable.
Right.
Like the poor child is terrible. Like he's paralyzed. He has no meaningful interaction apparently with the outside world. He's going to require a lifetime of attendant care. It's awful.
And that's what was interesting. The article didn't say what the life care plan was.
It didn't. They did make a couple of references to lifetime medical treatment. And I think that even the plaintiff's attorney was quoted as saying, we really felt like it should have been more than just the medical treatment, but making it kind of sound like, well, the $16 million settlement was just kind of for the for future medical treatment or attendant care. But I think the thing that maybe Governor Kemp would point out in this, or the tort reform people would point out in this, is This quote from the plaintiff's attorney, I want to get your guys' reaction about this. The quote is that the boy, in this case, nearly drowned due to Margaritaville's policy of not having lifeguards on duty at Paradise Beach's designated swimming area.
Right.
I find it interesting that they didn't say that he drowned due to the fact that he was underwater. I mean, there was.
So, I mean, this is a situation where you've got, corporation owning a business, inviting the public out there, come out here and swim. Now you have a tragic accident that happens to a child that could have been avoided by either putting up signs that say don't swim or putting a lifeguard on duty. So we're looking at profits over people. And then you've got a kid that gets terribly injured. It makes the community mad, it makes people mad, and that's how you get these big verdicts.
Well, now, can we pause here?
Because do you agree that this should have been a verdict of this size?
Actually, this is why I want to pause, is because this wasn't a verdict. Remember how we had that episode talking about the difference between a settlement and a verdict, right? This is a settlement,
right? So
they didn't even take this to trial. It was just a settlement, which means they voluntarily paid $16,000, agreeing that I'm guessing that they had
$16
some
million.
$16 million, agreeing that there was some exposure, right? But like Jason, how is this even public knowledge? It seems to me like, wouldn't this have been a confidential settlement, you think?
I'm surprised it wasn't.
Like, why? Right? Why would you?
I'm really surprised the insurance carriers didn't agree and insist on confidentiality, because these drowning cases, what it says is the mother wasn't watching her child in there as well. I've got young kids, or they were young. You have young kids. Whenever I go anywhere with my kids, I make sure I'm watching them like a hawk, especially there. And I know there was signage that said swim at your own risk. It didn't say no lifeguards. But if you show up at a beach and you don't see lifeguard towers, you've got to know no lifeguards are there. That's where I really struggle with on this case is, why is it the company's fault that the mother didn't watch her child?
Right. That's kind of where, I'm supposed to be on Dwayne's side on this, but I'm kind of not. Like, to me, the message that it sends to people is, never mind about personal responsibility. Never mind that you are responsible for your own child's life. Let's find somebody else to be responsible, and that's troubling.
But you got a lake. It's dangerous. You own this part of the lake. You're inviting tons of people there with their family, with their kids. Take that extra expense. It may cost you $30,000 a year, but if you're going to be open, either fence it off or put a lifeguard on duty so that this doesn't happen to other people's children. That's what people get upset with when we get these big verdicts. They're like, what about me? What about my kids? That's why they do these things, to punish these corporations.
Yeah, I can see that.
And they're not really looking at just this case, I don't think. Maybe they are.
Well, the people who settled it had to have been only thinking about their own circumstances, but
they were also worried that they could have got a bigger verdict than that at trial.
Right? You have to figure that $16 million is a compromise.
Right.
Right? That somehow, like, there was this thought that it could be considerably more.
Well, with a child having those type of problems in that age, and you start putting the numbers up with the mortality tables in front of a jury, you saw we just had 2 over $100 million verdicts come out in the last month. I'm sure they were worried something like that could happen here.
Right, and those happened in counties that we have traditionally thought as more conservative counties.
So how does an insurance defense attorney let that happen? Let $100 million verdict? Are they just not offering to settle for the policy limits? How do we get to that point where you get these giant nuclear verdicts at trial?
Well, there is an article.
Didn't know you were going to be put on the spot like that.
No, but I'm saying is, there's a perfect example. You don't have it here, but Ann Gower from our firm was on the Daily Report and it was in July. We tried a case, and there's a dispute over to whether or not a settlement was made and accepted on a 25 policy, and it's a 7-year-old who died. It's a very tragic case, but there's a separate bad faith lawsuit going on, and so we were just went and tried that verdict, tried that case because you've got to have the first part done before the
Right.
second
Oh,
part.
okay.
And so
Right.
it was, it was a very sad case, and obviously the other aspect of it's still going on, so I can't really talk much about it. But I can say what was in the article is it was a $14 million verdict in DeKalb County for the death of a 7-year-old, and it's one of the saddest cases I've ever tried. But it was one of those that unfortunately just had to be tried.
Right.
Right.
Well, and sometimes you end up with a case like this, right? Fulton jury award, you win, but they gave $0 in damages.
Is this the one about the dancing doctor?
Yes.
We were absolutely going to talk about that case, but not quite yet. I want to go back to something that you were talking about, Jason, about the 25, right? And because I can talk about it in theory, what happens is I'm the plaintiff's attorney, and I send a letter to the defense people, and I say, listen, if you pay the $25,000 liability policy limits, we will release your person from responsibility. But here's what you have to do. You have to send it on pink paper. It has to be underlined 3 times. It has to be received between the time of 3 o'clock and 3:05 in the afternoon of July 15th on a Sunday, right, in order to accept these terms, right? Now, I'm sort of joking, but there was a time where plaintiffs' attorneys would do that in this, what we call the gotcha game, right? In order to accept what I'm proposing is a contract.
Right.
In return for your $25,000, I will release your people from responsibility.
We still see some attorneys do it where they do like the little 2-line release. Here's our release that we're giving you. This is it. This is all you get. Send us the money or else.
It mostly got taken care of about 4 or 5 years ago when the plaintiff's attorney, the trial lawyers, and the defense lawyers kind of all got together and decided, okay, the defense lawyers were like, look, this whole gotcha stuff has got to stop. We have to have some kind of predictability. And so the plaintiff lawyers sat down with them and said, all right, we're going to draft this statute, and this statute's going to say what's acceptable to put in your demand and not acceptable. And that we all right, everybody agrees this is what we're going to do, right? And so they made it into law. So there's less of that now.
Well, except the new one we're seeing is, well, an answer's been filed, so the statute doesn't apply, so it's going back to the Wild West days.
Oh.
What?
So I get it now. Let me unpack that.
Yeah.
So the new argument from my people's side is this statute that says you can only send demand for the policy limits and preserve bad faith things if you follow the things in this statute applies to pre-suit pre-suit demands. But if it's already in litigation, that doesn't apply. That's what they're saying. Who knows?
There's
We'll see
no
what
appellate
happens.
court language on it, but I
I
have a
haven't seen
feeling.
any cases on that yet.
No, but I'll tell you, there is something in one of these. I highlighted it to talk about in another episode, but it's actually it's a contract issue. We made an offer, and the question is whether the response was a rejection of that offer and a proposal with new terms, or whether it was substantially similar enough. So we actually have to get like knee deep into contract law to determine like, okay, was there an acceptance, right? Because generally speaking, Dwayne, if I say, listen, write this down on a piece of paper, I'm going to pay you, I offer to pay you $10,000 for your antique cab over engine truck that we've been trying to get restored for 10 years.
That's right.
I agree. I will pay you $10,000. It has to be in writing because of the statute of frauds, which we'll talk about later, right?
Right.
Has to be in writing. And you say, I accept. Bam, there's a contract.
Sure.
Right? If you say, I will take 11,
Or let me add in this little extra.
or let me add this
Right.
extra
I can
thing.
drive it every Thursday.
Right.
Right.
Then you have rejected that offer and you've proposed a new offer.
Right.
And all I have to do is ignore it because it's not an offer anymore. Right. So that's what happens between us and insurance companies is we say, hey, pay $100,000, and sometimes the insurance company says, okay, we'll pay the $100,000, but we also want you to release from responsibility Joey, the husband.
Right.
Right, because he's the insured. And I say, oh, no, that's a rejection. We're suing you and we're going after hundreds of millions, and then you get that kind of trial.
Right.
So it does make things very interesting. We did kind of get away from the drowning case. I do want to bring it back to that because now what you said earlier, Dwayne, is correct. This Margaritaville, they were using that as a revenue generating thing.
Sure.
And that does come with some responsibility in the commercial world. Okay, you know, in my mind, I go back to, as I read this article, I go back to I grew up going to the beach as a kid and thinking, oh gosh, you know, like you can't sue God, you can't sue the water, you can't sue, you know, whatever. But you are right; they are using it for commercial purposes.
Right. Yeah. It's a little different than a beach, too. I mean, you know, although there are some places where you can't own all the way up to the water and all this kind of stuff. But with, you know, lakefront property, a lot of times they do own all the way to the water.
You know, my buddy Adam Taylor, do you know Adam?
Yes.
Yeah. Adam Taylor and I tried a land use case up in Cherokee County where our clients owned the lake. They owned the entire lake, yeah. I'm convinced we lost that trial because the jury members were like, wait, you own a lake?
Yeah, you're this rich? Give somebody else some money.
Wait, you own a lake?
Well, I think that
How do you
happens
do that?
a lot of times in plaintiffs' cases, too. I mean, people are like, oh, these corporations can afford to lose the money, but this family can't live without it.
There is
and
that
there's nowhere else for them to get it, so they feel sorry for them and give them these big verdicts.
I mean, I had a jury tell me that after one of my verdicts. It wasn't a huge verdict. It was bigger than I like, and they said, well, your client's, you know, the biggest so-and-so in this state, and this insurance carrier, $400,000 doesn't mean anything to them. And I was like, yeah, but the case wasn't worth that. And they're like, yeah, but it's no big deal.
It's no big deal.
I mean,
Which is why we're not allowed to talk about some of this stuff at trial, right? Why the juries aren't supposed to know some of these things.
All right, so I'm going to test this on you. I've been talking about this as at least the last 2 or 3 podcasts about my ongoing theory that maybe we should change the way we describe the jury's role to the jury while we're trying the case. And let me unpack that. Traditionally, because I'm swinging for the fences as a plaintiff's attorney, and you're swinging for 0 verdict or a defense verdict, we generally like the jury or want to like the jury to just determine the outcome of the whole case, right? In fact, the jury verdict form says the jury find in favor of the plaintiff for X dollars or for the defendant, like simple. But like, what if it was different? What if we were actually asking the jury to call balls and strikes, right? And use a special jury verdict form and say, you know, we the jury find that the defendant was more negligent than the plaintiff, right? And or we the jury find that that there was a duty or that they breached that duty, whatever, right? That we're having them focus more like referees in a game. Referees in a game don't. Well, absent the game that we watched last night.
Yeah, that was just a disgrace. But
I mean, but ordinarily, referees don't determine the outcome of the game. They determine how the balls and the strikes and the out and the safe. Say he's safe and he's out. Like why aren't we as attorneys trying to kind of avoid those weird, awkward conversations after the verdict by saying, no, your role is to determine what the damages are. The damages are this, right, or whatever. Like. What do you think?
No, it makes sense.
That's the first guest that's ever said that makes sense.
Well, I mean,
thank you. I promise I didn't prepare him for that.
No, well, I mean, but my last 4 trials have all been admitted liability, just damages. So I tell them, here's your role. I mean, that's what I've been doing. Say, look, here's all we're here to talk about. Or there was a little bit of issue of liability. I said, here's the issue on liability. You're not going to hear from me on damages today. Like, I try to limit it and focus on that issue as the important issue because otherwise they do get confused, and I want to try to keep the jury's focus on the issue that's important to me.
Right.
Well, let's see, on criminal cases, they don't get to talk about sentencing, right? So that's not even part of what they consider, how long they're going to spend in jail. Did they do X or Y beyond a reasonable doubt, yes or no? So it is really super focused. And I do feel like juries go back there and they freaking pick teams. They're like, I'm on this team, they're on that team, and I think they do it, after opening statements, and they go back there, start working
and just
on
start
their
like
case.
Mornin Ralph, Mornin Sam, start going around.
Yeah.
Well, in the few minutes that we have left, I want to take up one other one that struck me as an interesting case. This is a man who was at Canyon State Park, fell down a hole, in what this paper describes as a fenced-in area or a fenced area, and he fell 30 feet into a gorge, broke his neck, and is permanently disabled. He filed a lawsuit against the administrator, the caretakers of the park, and saying, so it was by a state agency, so it was part of Department of Natural Resources.
Yeah, I think it's got to be DNR.
Be something like that, and said that they had known about the hole for nearly a year, but no concrete steps had been taken to fix it. I don't think that they mean that that they were supposed
Nobody
to
put any concrete
install
in the hole.
concrete steps. I think just a poor choice of words. No steps had been, they hadn't done anything about it.
Right.
Yeah. They broke my rule about when you have the choice between saying things simple and saying things fancy, maybe you should just say it simple. At any rate, so what happened in this case was that it got dismissed. And it got dismissed because there is immunity for the actions taken by government agencies.
Which I hate qualified immunity.
I don't know.
I hate sovereign immunity.
I don't know if I'm with you on that.
I don't like it.
We're going to take up the entire thing about immunity in another episode, but I just wanted to kind of talk about, is this the kind of case that Governor Kemp would say or is ridiculous or frivolous?
Well, and I get it. You go to a gorge, a gully, right? A big hole, and you're hiking around, and then you fall in a hole, right?
It does. To me, it kind of goes back to okay, well, where does personal responsibility lie?
And I'll say from personal experience, you only have to fall about 20 foot to break your neck.
That's true. I forgot. Yeah. I forgot. That's how we really got to know each other, Dwayne, was because you had broken your neck.
Yeah.
And it wasn't doing something
I was mopping a porch.
Yeah. Couldn't you have done it?
No.
Something sexy?
How'd you fall 20 feet mopping a
Because it
porch?
didn't have a railing on it, but we were in Jamaica, so nobody to sue.
There was,
There may have been a sobriety issue, too.
No, I was on a church trip. I was completely sober.
oh no! So not only were you in a foreign country where they would look askance at filing a lawsuit, but you were also working with a church where if you sued,
Yeah, we're on the little campus there. Yeah.
Oh gosh. Oh, that must have been. Well, I imagine that was painful.
Well, personal responsibility. You don't put wet, soapy stuff on a porcelain porch.
Porcelain.
Yeah, unless you want to fall off.
Right. Especially if there's no railing.
That's right.
It is kind of on you.
Yeah.
Have you had to deal with that kind of with that kind of case where there's this element of personal responsibility and you're like, hey, this doesn't seem right to me?
I've had several where people tripped over the warning cones.
The warning cones?
Yeah.
Oh my God. There was no
and I lost on summary judgment, which is I think part of the problem with it.
So the store put out the warning cones like they're supposed to. They tripped over them. Wow. I wouldn't have even taken that case. I would have been like, that's not a case.
I think I would have too. Or I would have said, that is the most terrible case I think I've ever seen. You might have a 5% chance of winning. They ought to pay you, if you have a $100 case, they ought to pay you $5.
You need a second opinion, and then I'd give them some attorney in town to call. Right.
Well, Jason, I really appreciate you joining us. If you ever have a chance to join us again, we'd love to have you on again. And make sure that you subscribe. We have literally hundreds of subscribers, and we want it to be thousands. Understand, the TikTok people or whatever, there are, my son watches this YouTube stuff, and there are millions of subscribers.
Right.
But that's because the potential audience is billions, right? We're really only promoting our podcast to Georgia.
Right.
And so having hundreds of subscribers, I think, is good because it's a much smaller base or much smaller population. So, but still, don't rest on your laurels. Please.
Subscribe.
Like and subscribe.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.